Also wanted to let you know, coming up, Mike Fagg, my counterpart on the Senate side, and I both wrote a joint letter down to Southwest Power Pool in Little Rock, Arkansas, requesting that they be up here to appear before the committee on March 12th. So that's going to be coming up too. Should be some good information coming out of that one. Other than that, I think we're just going to jump on in here. We've got a hearing today on House Bill 2806. Mr. Nick, if you'd like to fill us in on that.
Yes, good morning, everyone, Mr. Chair. Committee, House Bill 2806 would create a new law within the statutes to establish certain rights and limitations relating to how the public right-of-way is used by certain telecommunications providers, broadband providers, and video service providers within county public right-of-way. So what this bill would do is it would grant these telecommunication, broadband, and video service providers the right to construct, maintain, and operate their facilities within that county public right-of-way, as long as that right-of-way use does not obstruct or hinder travel, public safety, or other lawful uses of that public right-of-way. So this bill would prohibit a county from establishing any discriminatory or unreasonable condition or barrier that prohibits a provider from using the public right-of-way. And then if a county does impose any access or permit requirements to use the public right-of-way, those requirements must be implemented in a non-discriminatory and competitively neutral manner amongst all the similarly situated providers. The bill would also limit the fees that a county could assess against providers for using the public right-of-way, and those fees also have to, if imposed by a county, also have to be based on the county's reasonable, actual, and verifiable costs of managing that public right-of-way. So the bill would authorize the following fees. County could assess a construction permit fee to set their fixtures in a public right-of-way, an excavation fee for pavement cuts that are made for the work, and then also an inspection fee for inspection work that's performed. If a provider were to cause damages, the county could assess a cost to repair those damages. Additionally, the bill would authorize the county to also require a provider to provide a performance bond to ensure against the appropriate and timely performance of any work that's being done. The bill, as I said, authorizes those fees, but then the bill also prohibits the imposition of any other fees or costs that are not specifically outlined in the bill. And then upon request, the bill would authorize a provider to request that a county provide an accounting of the costs that are incurred by the county that are the basis for any fee imposed by the county. Finally, the bill would prohibit a provider from entering into a contract with a county to provide a product or service that provider's business does not actually sell or provide. And I will note, Mr. Chair and members of the committee, a lot of the provisions of this bill are based, and what I'm seeing is kind of pulled from a current law in the Kansas statutes, which relates to public right-of-way use for these same providers. But this statute, 17-1902, relates to public right-of-way use in cities. This bill applies only to county public right-of-way use. And Mr. Chair, members of the committee, if enacted, this bill would take effect on July 1 of this year, and I'd be happy to stand for questions.
All right, committee questions. We've got Representative Williams. Go ahead.
Thank you, Mr. Chair. I know we heard this bill last year. Are there any changes to the bill we heard last year?
So I was just looking for that bill, and I saw the bill number yesterday, and I couldn't find it last year. The bill last year was amending that statute that I just discussed, 17-1902, to, and I'm trying to remember, basically putting counties within the exact same statutory framework as the city public right-of-way statute. This statute would be a wholly new section of law, and there are a few little differences between the two statutes, but I could get some more information on that, maybe some of the differences if you would like.
No, I was just curious. Thank you. Thank you.
Yeah, you're
No,
welcome.
and you're welcome to follow up with her on it. The one last year, I believe we heard it. I do not believe it ever got worked. But this one here has been worked amongst the people, the parties of the bill, if you will. So, yeah. Any other questions for the revisor? Representative Berquist.
These, thank you, Mr. Chair. These fees would be equal amongst all providers, reasonably equal, but would they be subject to the linear measurement of the project or the size of the project as to how much fee it would be? Could they be different fees according to the size of the project?
I think what the bill is saying is that the fees just have to be non-discriminatory and competitively neutral. So the fees, essentially what that's saying is those fees, if the county is going to choose to do it that way, it needs to be done that way for every similarly, I can't say that word, every same similarly situated provider. Counties would still probably have some options in the ways that they structure their fees within this framework. But again, it has to be competitively neutral and non-discriminatory amongst those providers.
Thank you, sir, and thank you, Mr. Chair.
You're welcome.
And my vice chair.
Thank you, Mr. Chair. A couple of questions. One of them is at the beginning, this section 1A, where it goes through a number of statements there. I see those on some bills and I don't see it on others. I've seen it struck because it just confuses. What's the value or purpose of such statements as 1, 2, 3, and 4 under 1A?
So those I would say are just kind of declarations of legislative intent. And if some lawsuit were to ever come from this statute, I could see some good attorneys pointing to those declarations of legislative intent and making and crafting their arguments of why their position is the right position or not. But as for the legal structure of how and counties could use those too, as to kind of to see how they need to structure their processes under this statute. But as for the true legality, those are just declarations of intent.
Okay, thank you for that. And then second thing is under J, where as you mentioned in your summary, it gives them the opportunity to get an accounting for the costs. Is that that's not in the other bill as I understand it, but is that typical where those being charged a fee have the ability to have the tax or the feeing agency disclose their books to see the reasonableness?
So I don't know the answer to the second question, whether it's typical or not, but I do know that that is a provision, like you mentioned, that I do not believe is within the parameters of 17-1902, the city public right-of-way statute.
Okay, one more if I can, Mr. Chair, and that's you had mentioned in your last paragraph of your summary that it would prevent a provider from entering a contract to provide a product or service that the business does not actually sell or provide. I wondered what's behind that, or what examples might there be? That's kind of an odd statement. Thank you.
I think that's an excellent question. I don't know the answer to that either. It might be a good one for some of the conferees to speak on.
Further questions? Okay, not seeing it. And I want to just elaborate on the previous questions there, but it was on line 21 on the first page. Public right of way means the area of real estate, and it goes on to includes the area on, below, or above. I mean, are there limitations here? How far down are we talking? How far above are we talking? I mean, to me, it just seemed like kind of an open.
So, yeah, and it might give you a little solace to know that that definition, I believe, is exactly, or let's see. It's basically the exact same definition that's currently in statute under 17-1902 for a definition of public right of way. So it's the definition that cities are using under the statutory framework for the definition for a public right of way.
That's what I want to verify. Okay, any further questions? See any? Thank you, Nick. Appreciate it. So first up, we've got in person is Megan Bottenberg. You out there, Megan? Oh, there she is, hiding in the back with Cox Communications. Welcome to the committee.
Good morning. I feel like, although I really should not be the first one up here, but happy to do it. Happy to answer any questions that you all may have. Good morning. My name is Megan Bottenberg. I am the Director of Government Affairs for Cox Communications. We want to first and foremost appreciate and let Idea Tech and AT&T know how much we appreciate their partnership in bringing this bill forward. I know that it was a topic of discussion during the last session, and over the past month and a half, and even longer for Idea Tech and AT&T. But we appreciate them bringing us into the conversation and allowing us the opportunity to all work together. This is a great demonstration of three different providers who compete against each other all the time, but working together, because at the end of the day, we all have the same goal, and that is to make sure that broadband is deployed to unserved and underserved areas throughout Kansas. And as the landscape for that in this market changes on a regular basis, and from a Cox perspective, we've seen it both here in Kansas, but also across the country. We all want to be treated the same, fairly, have the same opportunities just as anyone else in the public right of way. The public right of way is, something that is incredibly important, should be treated fairly so that we can all deploy broadband the best capabilities that we can. You obviously have my testimony in front of you, and I won't go line by line, but I just wanted to highlight and give you a couple of examples as to what Cox has faced just recently here in Kansas to demonstrate how important this legislation is. And again, this legislation provides us non-discriminatory, competitively neutral playing field, and that's what's important for Cox. Again, to give you an example, just recently, one community here in Kansas lowered their permit fees for one provider, but did not make it clear for other providers. And so for other providers, we're going to have to go and ask for that same thing when we want to build out in that area. So again, it's just picking winners and losers. We don't want that to happen. We want to be sure it's fair. Another example is a county was approached by another provider to provide an exclusive variance to not bury their lines as deep. And again, want to be sure that it's not exclusive variances, that everyone is treated the same in the public right of way. Another example, a community allowed a provider to enter the right of way without any right of way fees, only having to pay permit fees. So sometimes when you enter the right of way, we enter it paying franchise fees. This isn't about franchise fees, but paying franchise fees, other providers enter the right of way paying a right of way fee, perhaps a cost per linear foot, whatever the case may be. Again, needs to be the same for all providers, and that's what this legislation does. Again, happy to answer any questions that you may have. We appreciate AT&T and Idea Tech for working with us and the partnership that we've all demonstrated.
Thank you, Megan. Questions for the speaker? Not seeing any. Well, thank you for being here. And if something comes up, we can always call you back up. So appreciate it. Next up is Daniel Friesen with Idea Tech. Welcome to the committee, sir.
Thank you, Mr. Chairman and Vice Chair and distinguished members of this committee. My name is Daniel Friesen. I'm the Chief Innovations Officer and co-founder of Idea Tech. It was started by a group of high school kids in 2000 in Buhler, Kansas. Our mission is to serve the underserved. We spend a lot of time in rural Kansas building fiber. We've built about 6,000 miles of fiber all over the state, from east to west, north to south, focusing on those that are most underserved. As was said, we're here today on House Bill 2806. We think it's a pretty simple bill. I know a lot of it's kind of already been mentioned. While it has a bit of language in it, it's ported almost completely from 17-1902, as was mentioned. Just a little background on myself. I feel like I'm uniquely positioned here today as both an entrepreneur. I served on the Kansas Broadband Task Force, as well as I'm a county commissioner in Reno County. And so I can see both sides of this bill for sure. We feel like there's equal protections here. It's a very kind of equity-based bill where counties today don't have explicit authority to manage the right-of-way, to require performance bonds, to have the authority to collect when damages occur, although they do that today. On the other side, broadband providers have been operating under 17-1902 for a few decades, as well as municipalities. It seems to be a great bill that works in both directions. And so today we're seeking that uniformity to be brought to the county level. And you might ask, why was this never done? There's probably two reasons. If you read 17-1902, there's an argument that it says all right-of-way in the state could apply to counties. There's been some conversation on that. But the other reason, I think the bigger reason is I would estimate that 20% or less of all of the broadband infrastructure, telecommunication infrastructure exists in unincorporated counties. And it just hasn't been a priority. There hasn't been a lot of work, frankly, in these areas. And these are the areas that need the most work. And if you are following all of the broadband efforts, especially in Kansas, the broadband office has over $450 million to outlay in the next year. And that's going to go to the most rural parts of the county. So setting up broadband providers to kind of have these equal rights that are in municipalities is going to be most important, because that $450 million is going to be going to that 20%. And so that's probably the reason why we haven't heard a lot from regulating county right-of-way. I think there's been a lot said already. We definitely want to also recognize our peers and partners, Cox and AT&T. If you asked me 10 years ago if I'd be working with Cox and AT&T, I'd probably be surprised to say yes. But they've been good partners. I think we kind of fixed some of the issues that were kind of holding this bill up last year. One of them being it just did not work to kind of modify 17-1902, and that's why this new statute was created and proposed. Like Megan mentioned, there's a lot of great counties in Kansas that are very pro broadband and are very supportive. We do see some inconsistencies, and we agree with her testimony on the fact that counties can treat providers differently and support that idea. I think our focus has been more on a few counties in the state that have just been far off the spectrum from a cost perspective. So far off, they look more like a tax than a fee to recover costs. And our argument, and I think it's well based in state laws, that counties can't tax a broadband provider like that. And so this kind of clears up that issue. Just some examples on both sides. KDOT, which has some of the most advanced right-of-way in the state, charges $0 because they are very connected with the priorities of broadband expansion in the state. We have a lot of counties, such as Reno County, that charge reasonable kind of cost-based fees. Reno County charges $50 for a permit fee. Sedgwick County's $125. And then you kind of just fall way off the cliff with a few counties. And I don't want to mention them because they're still good partners, but we have counties that are charging tens of thousands of dollars. We had a proposed fee in a very rural county of over $20,000 for permit fees. And at that point, it becomes less about recovering costs and more about generating revenue, which I know as a county commissioner is important to counties, but we do not think it's the appropriate avenue. So, just to kind of close out, and I'm happy that there were a few questions that I'd love to follow up on here with you guys. In general, we think this is a very aligned. The counties have a very important priority. I mean, they've said it in their legislative priorities themselves. Like broadband expansion is a key important part of growing the rural economy and supporting, one of the primary, industries of our state. And, connecting that legislative priority with the broadband providers' priority of just getting out to these last 20% is really going to make the difference. We feel like this bill strikes the proper balance of those priorities and connects with the broadband planning task force of developing, amending, and reducing policy and regulation, which reduces barriers. And by doing this, we're speeding up broadband deployment. And I know it seems like less and less people are connected to this issue because more and more people are now served properly. But there's still 10% of Kansans that do not have adequate broadband access. They, take their kids to libraries, to McDonald's to get proper Wi-Fi. They can't work from home. They can't do their homework from home. So this is, as we get closer to solving the problem, I think we're less aware that there's still a problem out there. So again, this bill kind of sets the stage for county right-of-way work, conforms with 17-1902, which has been tested for a long time and works well. So with that, we'd respectfully request that you consider this bill and the equal protections that are included in here. So thank you, Mr. Chair. With that, I'll stand for questions.
All right. Thank you, Daniel. Committee questions? Got a few. Representative Schlingen-Siepen.
Thank you, Mr. Chairman. I saw here in the Director of the Budget's neutral report, the Kansas Association of Counties indicated that the enactment of the bill could have a fiscal effect on counties depending on whether there are other costs associated with the public right-of-way that are not listed in the bill. Since you're sitting on both sides of this, I thought I'd ask you about this. Is this just kind of a CYA statement in case there's something else that sort of pops up that isn't listed in the bill, or are there in fact identifiable other costs that have been identified?
I really think this is just going to prevent the kind of egregious examples. It's really hard going into a county and arguing that their costs aren't fair if they appear fair and they're kind of in line with their peer counties. And you see that, I mean, if you kind of, scattered these on a board, you have a very high concentration of reasonable costs, and then you have a few outliers. We're trying to kind of solve for that. And so generally, it's not wise for any provider to argue or litigate with the governing body that they're trying to work with, and so you don't see that very often. And this is an attempt to get in front of that fight. And so, from the other side, from the county side, I trust, our county employees when they say, $50 covers the cost of issuing a permit. And so it's just really hard to argue that you need $10,000 to issue a permit. So I think we're looking more in that direction.
Representative Proctor.
Thank you, Mr. Chair. Thank you for being here today to talk about this bill. I'm kind of shocked to hear you say only 10% of Kansans are not covered by broadband. My entire rural area, no broadband out there. Where do you get that figure from? And I'd also, since while you're commenting, if you can comment on the system by which the locations where broadband, state assistance for broadband is occurring, if you could talk about that as well.
Well, Representative, I have to admit that was a bit off the cuff. I have the actual number, and it's probably a little more than that. And as you mentioned, definitions vary widely. There has been some significant process from the broadband office, and this legislature has invested a lot of money in connecting communities. We'd love to talk to you about your particular needs and find out. And so, you know, again, off the cuff, there are many customers in more urban areas that would say they're not well served or they don't have the right amount of competition. And so I think completely agree with you. There's a lot of work to be done, and fully understand there are communities like yours that need a lot more work, and this is a component of that work is just helping providers, reducing barriers to get to you. So I'll get you the right number.
If you could also, what I have heard anecdotally is that the Office of Broadband and the way that they're kind of allocating or deciding this area is going to get assistance with providing broadband, that the veto power of one company that's serving a close by locality over another company wanting to provide service has been a hindrance. Could you comment on whether that's true or if you've seen any of that?
Yeah, I mean, there are kind of 2 points there. I mean, you're kind of speaking to mapping and the accuracy of mapping, and then speaking to the challenging rights of incumbents. If I understand your question, the maps have never been fully accurate. They're getting better, and so it's unfortunate, but you have to rely on some baseline for where you put your money. The state's been working hard on that, and we do think that's getting better. The particular point you raise is valid, and we've seen it where very viable and important projects are getting spoiled by frivolous challenges, and sometimes very inaccurate challenges. I think one of the problems we're seeing is there's so much need. Right or wrong, the broadband office has been looking to fund kind of clean applications that don't have challenges, and so I think that would be a good point to relay back to the Department of Broadband, that not every challenge is equal, and they probably should consider all applications, even if they're challenged, and kind of remove challenges that don't have merit. So you're right. There's a problem there.
Further questions? Representative Turner.
Thank you, Mr. Chair. I'll ask you what I asked the reviser. So what is section M where it's talking about no provider can provide a service that they don't actually sell or provide? What is that intended for?
That's a good question. I think the answer would be better answered by some of our other partners. Frankly, just to be transparent, that wasn't an ad by us, and so I can't answer your question on that one, but I can get you an answer.
Okay, I would appreciate that. Secondly, is when the county produces the background behind their fee structure, who's to say that you guys still don't like it? Because there's nothing that defines what can go into that bucket of costs, so they can be creative in terms of what they include and what they don't. So once they produce that, then who's the reasonableness police to say, yeah, that's okay?
Well, that's a great question. I'm glad I got the opportunity to answer this, because we've seen that this bill doesn't solve all the problems. And we've had problems in cities that are under 17-1902 that have the reasonableness, non-discriminatory requirement, and they're charging exorbitant fees. And so that language, as you astutely noted, there's a difference in the two. And there's one of the differences is, if a provider asks, a county has to provide substantiation. And that comes from our experience where arbitrary numbers are thrown out. And again, we have these kind of average costs. And then we have a city over here that's, charging tens of thousands of dollars and getting franchise fees on top of it. And so the intent there was just to add another layer of, just diligence in like, hey, can you please explain where these costs are coming from? At the end of the day, again, it is very rare for a provider to get in litigation with a partner community. And even in those situations where, there were egregious costs, we were able to point to the legislation, kind of hold them back a little bit. They were still high, but we felt like this would help in that conversation without reaching the level of having to fight it in court. So we feel like it's actually a point that would reduce the threat of legal action.
But in the end, it could still go that path if we still disagree.
Certainly, we've just never taken that route. We don't have time.
So the other thing was, I think in your comments, you said you currently apply 17902 roughly as a guideline. Is that fair?
That's true.
But you didn't choose to modify it. And why was that? I'm just curious why it wasn't something we could twix to include counties as well as cities.
I'm not probably the best at explaining all of the challenges with amending current law. I do know that it was a primary factor in why it didn't get worked last year, and the complexities. I wish, and I think I did this myself. I just took the definition of city and added county, and it just, you start to get kind of conflicting language. And I'm sure the reviser could explain more, but there are, different rules applied to cities and counties. And as you kind of go through that bill, there's a couple challenges of just amending 17-1902. And so this was the cleaner approach of just separating the two and not trying to, break something or fix something that isn't broke today in 17-1902.
Okay, thanks. And I guess behind that was, and I didn't ask the Cox testimony, but it says that legislation is anticipated next year that will allow the same fairness in the city. So apparently 17902 isn't currently viewed as being a good or fair statute.
I wouldn't say that. I would say that you're going to see the differences you see in this bill versus 17-1902 are coming from a few decades of experience from the industry. And so there are enhancements that I think work on both sides. And so, I would say maybe the intent of that comment was some of the good stuff we've learned over time should be amended into 17-1902 if this bill passes.
Thank you, Mr. Chair.
Further questions? Okay, I've got a few before you sit down here. Last summer, I attended a couple of the meetings that you guys had, but I just want to publicly state who all came to those meetings, like the one we had down at the Wichita Chamber. Can you I want everybody to know who all was in on this bill, putting it together.
Yeah. So, we've, and I honestly, Mr. Chair, I may not have been at that meeting. So I do know it's been very collaborative, certainly from the industry. One thing we do see is there's a lot of public interest in supporting broadband bills. And so the public has been involved pretty heavily in all of these efforts. And ask anybody that's underserved and they want any sort of barrier reduced to get out there. Because if you think about it, if there's not a business case to get to a certain location, you're increasing the chances of that business case working when you reduce barriers. And so I know I avoided your question a little bit there, but I'll get you a better answer.
I'm pretty confident you were there. Okay. Do you think the parties here today have all got a portion of this bill? I'm referring to the Coxes, the Idea Tech, the AT&Ts. I mean, I looked through the bill and it looks like everybody's kind of involved there.
We've had half a dozen meetings, and this is especially for us unusual to be working, very directly with competitors, but I think it shows how important it is to the industry. And so definitely we've seen collaborative work across the industry, even those that may not be represented directly here. I think we've heard from, including some rural telephone companies in the last 24 hours. The broadband office reached out to us because they had heard, hey, we have an issue with a broadband provider getting charged high permit fees for an application that we funded, and that's pushing the costs above what they estimated. And that happened 24 hours ago. We're like, you should probably come support this bill. And so I think they've are starting to experience the same thing.
Okay.
Definitely a lot of collaboration.
When you're running along, I assume you got fiber along highways, et cetera, but you end up working with KDOT to pull permits. What kind of average turnaround do you get if you apply for a permit? How long does that take?
Well, there's 105 counties, and so there's
There'd be one KDOT.
So if you're talking about KDOT specifically, they're doing really well. The last secretary has really put an emphasis on supporting broadband as an important policy of the state. Secretary Reed has been welcoming industry input on this issue, and they, when we started 15 years ago, KDOT maybe wasn't as connected with the importance of broadband, and they're focused on building roads. We're focused on building virtual roads, and they didn't make that connection for a while. But in the last 5 years, especially, KDOT has been very good to work with. Their turnaround times have been good, and they actually implemented a new permitting system, a statewide permitting system that is actually very good. And for a government application, that's not always the case, but they're doing good work there.
Can you give me some feel? If you apply for a permit, is it
less than
a week? Is it a month?
2 weeks.
A couple weeks. Okay,
Yeah.
That's what I was looking for. All right. I think that's all I got for questions to you. I do have one for Nick, if you don't mind, to the revisor. But you've heard us go through this bill, and I know you had your hands into putting the actual bill together. But does it fix the things we're after? My concern is we're stepping on toes of counties and cities and so, et cetera. Is this bill going to do what we are intending it to do? Your opinion?
That's a good question, Mr. Chairman, and I don't know that I can provide much of an opinion in my capacity as a revisor on that question, because I don't know what each one of you has in mind of what you're wanting to fix. So I think your best point of contact for that type of question is the conferees that are in front of you today.
But there's no obvious things that stick out to you that maybe we need to tweak it here and there, as far as wording or anything.
I'll be happy to work with anybody if anybody sees anything that needs adjusted. One thing I would like to know that I did say, and I said the definition of public right of way to your question was the same as 1902. This definition does have one difference, and it's the KDOT portion. So this excludes KDOT public right of way or structures, property, and facilities under the ownership, control, or jurisdiction of the Secretary of Transportation. So those are excluded from this bill. So as the conferee noted, the process with KDOT would be not included in this, but subject to the KDOT process.
Okay, that's good input I was looking for. Any further questions? Okay. Thank you,
Mr. Chair.
for being here, Daniel. I appreciate you coming up. So I'm not showing any other proponents in person. Is there anybody else out there that would like to speak? Not seeing any. We do have a written only from Darren Miller, who is there, but he is with AT&T. In that committee, you should have the written only from them. I do not show any opponents. Is there anybody out there that would like to talk for an opponent here? Not seeing any. And we have a neutral written only from Jay Hall with Kansas Association of Counties. With that, anybody wishing to speak as a neutral? Not seeing anything. Okay, we will get to work on this one, and I will close the hearing on House Bill 2806. And committee, that is all I've got for today. I do want to throw one thing out. It might have been a typo when I read it, but the SPP meeting, I was handed a note, it's on March 21st, not the 12th. So if you're taking notes on that, that's when they will be up here. So with that, anybody, any comments or discussion? All right, we are adjourned.